If you are over 60 years old, an immigrant, a green card holder, or someone who was not born, a United States citizen, a completely new banking report rule is coming in 2026 that could turn your entire financial life upside down. And I want to be very clear with you right from the start. This is not just another small regulatory update that you can ignore. This is a fundamental change in how the United States government tracks, monitors, and enforces rules about foreign bank accounts. And it specifically targets seniors and immigrants in ways that have never happened before. Imagine this scenario for just a moment. You have a small savings account in your home country that you opened decades ago. Maybe it has $8,000 in it. Maybe you use it once a year when you visit family. Maybe you have not even thought about it in years because the amount is so small. You have been filing your taxes honestly every single year, and you assume that because this account is tiny and you rarely touch it, it does not matter to the IRS or to any other government agency. Then one day in 2027, you receive a certified letter. It is from FinCEN, the Financial Crimes Enforcement Network. The letter says you failed to report a foreign financial account. The penalty is $30,000. Your bank accounts in the United States are frozen pending investigation. And if you are in the middle of applying for citizenship or trying to renew your green card, your entire immigration case is now in jeopardy. That scenario is not made up to scare you. Under the new 2026 rules, situations exactly like this are going to become shockingly common unless people understand what is changing and take action right now. The good news, and I really mean this, is that nothing in this video is designed to frighten you unnecessarily. The entire purpose of what I'm about to share with you is to prepare you. If you know what is coming, if you understand the new requirements, and if you follow a few straightforward steps, you can protect yourself completely. You can avoid penalties, avoid audits, and avoid any problems with your immigration status. Over the next several minutes, I am going to walk you through exactly what this new banking report rule is, who it affects, why seniors and immigrants are being singled out, and most importantly, what you need to do right now to stay safe. By the time you finish this video, you will know whether these changes apply to you, and you will have a clear action plan that you can start implementing today. So take a deep breath, try to relax, and let's go through this together, step by step. I have spent years helping seniors, immigrants, and green card holders understand complicated United States financial regulations and immigration rules in a way that actually makes sense. I know from personal experience how overwhelming banking and tax regulations can feel, especially when you are dealing with retirement on a fixed income, or when you are navigating the stress of immigration paperwork while trying to build a new life in America. Most people just want to follow the rules, support their families, and live their lives in peace. But when the government suddenly changes something important without making it clear or easy to understand, it creates confusion, fear, and sometimes terrible consequences for honest people who never intended to do anything wrong. That is exactly why I am here. My goal is not to use legal jargon or technical language that makes you feel stupid. My goal is to explain these new rules in plain, simple English so that you can make informed decisions about your own situation. I promise you by the end of this video, you will understand exactly what is happening and exactly what you need to do. So let's get started. First, let's answer the most important question. What exactly is this new banking report rule? Starting with the 2026 calendar year, which means the reports you will file in early 2027. FinCEN and the IRS are jointly launching what they are calling the Enhanced Foreign Account Mandatory Reporting System. This is a dramatic expansion of existing foreign bank account reporting requirements, and it introduces several changes that will affect millions of people who have never had to worry about these rules before. Here are the main changes you need to understand. Number 1, the reporting threshold for foreign bank accounts is being dramatically lowered. And this lower threshold applies specifically to two groups of people: seniors over the age of 60 and anyone who was not born a United States citizen. Under the old system, you only had to report foreign bank accounts if the total combined value of all your foreign accounts exceeded $10,000 at any point during the year. That threshold is staying in place for younger people who were born in the United States. But for seniors over 60 and for immigrants, the new threshold drops to just $5,000. In some cases, depending on your immigration status or citizenship application timeline, it could drop even lower to as little as $3,000. Number 2, the definition of what counts as a foreign financial account is being expanded. It is no longer just regular checking and savings accounts. The new rules also include foreign retirement accounts, foreign pension funds, life insurance policies with cash value, prepaid debit cards issued by foreign banks, digital wallets held with foreign financial institutions, and even partial ownership interests in foreign properties or businesses if those interests generate any kind of financial return. In simple terms, if you have any money, any asset, or any financial connection outside the United States, and if it has any value at all, it probably needs to be reported under the new system. Number 3, and this is perhaps the most significant change, FinCEN, the IRS, and USCIS are now implementing complete real-time data sharing. What does that mean in practical terms? It means that every piece of financial information you report to the IRS will be automatically cross-checked against records from the Financial Crimes Enforcement Network, and all of that information will be immediately accessible to United States Citizenship and Immigration Services. If there is any inconsistency, any missing information, or any account that appears on one agency's records but not on another, the system will generate an automatic notice. In many cases, it will trigger an immediate investigation. There is no longer any possibility of something slipping through the cracks or being overlooked because it seemed too small to matter. Number 4, the new system eliminates almost all exemptions that used to exist for small accounts, inactive accounts, or accounts that are jointly held with family members. Under the old rules, many people were able to avoid reporting certain accounts because they fell into special categories. Those categories are disappearing. Starting in 2026, if you meet the age or citizenship criteria, and if you have any foreign financial connection above the new lower thresholds, you must report it. Period. There are no exceptions for accounts you rarely use, accounts you share with aging parents, accounts you opened decades ago and forgot about, or accounts that only hold a few thousand. Now, I know what many of you are thinking. You are thinking, why are seniors and immigrants being singled out? Why is the government creating different rules for different groups of people? The official explanation from FinCEN and the IRS is actually quite straightforward, even if it feels unfair. According to multiple government studies conducted over the past 5 years, seniors over 60 and immigrants are the two demographic groups most likely to have unreported foreign financial accounts. Not because they are trying to hide anything, but simply because they do not understand the reporting requirements. Let me explain the reasoning behind this. Seniors, especially those who are now in their 70s, 80s, or 90s, often lived very internationally mobile lives. Many retired abroad for periods of time and then returned to the United States. Many worked overseas during their careers and accumulated savings or pension benefits in other countries. Many maintained bank accounts in their countries of origin to make it easier to visit family, pay for medical care, or handle estate matters. From their perspective, these accounts are just practical conveniences. They are not trying to evade taxes or hide money. They simply never realize that United States law requires reporting of worldwide financial assets regardless of where those assets are located or how small they are. The same pattern applies to immigrants and green card holders. Millions of people who move to the United States maintain financial ties to their home countries. They keep bank accounts open to support elderly parents. They hold on to small retirement savings from jobs they had before immigrating. They own partial interests in family homes or small businesses. They may even receive modest pension payments from foreign social security systems. To them, these financial connections have nothing to do with their lives in America. But under United States tax law, they absolutely do. The problem is that many immigrants simply do not know this, especially if they came to the United States later in life, or if English is not their first language. So instead of continuing to rely on people to somehow discover obscure reporting forms on their own, the government has decided to make it impossible to miss. By lowering the threshold specifically for seniors and immigrants and by placing new mandatory questions directly on standard tax and banking forms, FinCEN and the IRS are essentially eliminating any excuse of "I did not know." And by creating automatic data sharing between agencies, they are making it nearly impossible for unreported accounts to remain hidden. Now, before we go any further, I want to pause for just a moment. If what you are hearing right now is new information that concerns you, please take 1 second to like this video. The reason I ask is simple. The more people who like and share this video, the more seniors and immigrants will see it before they accidentally get themselves into serious trouble. These rule changes are complicated, confusing, and the government is not doing a good job of explaining them in ways that ordinary people can understand. So, by liking and sharing, you are literally helping to protect people in your community. Thank you. Now let's talk about how these new rules affect different groups of people. Because the impact is not exactly the same for everyone. If you are a senior who was born in the United States and who has always been a United States citizen, you might be thinking this does not really apply to you. But that assumption could be very dangerous. Under the new requirements, any person over the age of 60 who has any foreign financial connection will be required to answer enhanced reporting questions on their annual tax return. If you receive even a small pension from another country, if you have a bank account overseas, if you own any part of foreign property or investments, or if you maintain any foreign financial account for any reason, you will now be required to disclose that information in much greater detail than ever before. The IRS is no longer treating foreign assets as something that only wealthy people need to worry about. Under the new system, even a small dormant account with $3,000 in it will trigger reporting requirements if you are over 60. Even an account that you only use once a year when you visit family abroad will count. Even accounts that are jointly held with siblings or aging parents will need to be reported if you have any access to them or any signature authority over them. The assumption built into the new system is that if any foreign financial connection exists, it must be reported properly, completely, and in detail. For green card holders, the situation is significantly more serious. As a lawful permanent resident, you are already required to follow the same tax and financial reporting rules as United States citizens. That has always been true. But what makes the 2026 changes especially critical for green card holders is the direct connection between financial compliance and immigration status. When you apply for United States citizenship, USCIS conducts a thorough review of your tax history as part of what is called the good moral character requirement. Under the new enhanced data sharing system, USCIS will have immediate automatic access to all of your IRS and FinCEN records. This means that immigration officers will be able to see whether you correctly answered the foreign account questions on your tax returns. They will be able to see whether you filed all required foreign account reports. They will be able to compare the information you provided on different forms and identify any inconsistencies, any missing details, or any accounts that were not properly disclosed. And here is the critical point. Even if your failure to report was completely unintentional, even if you simply did not understand the rules, that mistake can still create serious problems during your citizenship application. It does not necessarily mean your application will be denied, but it absolutely can trigger delays, additional questioning, requests for more documentation, and in some cases, referrals for further investigation. In the most serious situations, repeated or significant failures to comply with financial reporting requirements can be used as evidence that you do not meet the good moral character standard, which can result in denial of citizenship. That is why green card holders need to be extremely careful, extremely thorough, and extremely proactive about complying with the new reporting requirements once they take effect. If you are a naturalized citizen, you might assume that because you are now fully American, these special rules no longer apply to you. Unfortunately, that assumption is incorrect. The new regulations specifically include naturalized citizens in the enhanced reporting group. The reasoning is straightforward. People who were not born in the United States are statistically far more likely to maintain ongoing financial relationships with other countries, even many years or even decades after becoming United States citizens. So even though you have exactly the same legal rights and responsibilities as any other American citizen, you will still be subject to the lower reporting thresholds and the enhanced monitoring that applies to immigrants. And finally, for those who are in the United States on work visas, student visas, or other temporary immigration statuses, these rules can matter just as much. If you meet the substantial presence test for United States tax purposes, which most people on long-term visas do, then you are required to file United States tax returns and comply with all financial reporting requirements. For visa holders who hope to apply for green cards in the future, or who may eventually want to become citizens, your tax compliance history matters enormously. Problems with IRS or FinCEN reporting can complicate visa renewals, can create issues during adjustment of status applications, and can even be used as grounds for denial of immigration benefits. So to summarize this section, the new 2026 banking report rules reach far beyond just retirees. They touch almost anyone who has lived, worked, or maintained family connections across more than one country. And the consequences of failing to comply can range from significant financial penalties all the way to serious immigration problems. So now we come to the most important question. What should you actually do to protect yourself? Instead of worrying or feeling overwhelmed, the smartest thing you can do is take a few practical steps right now, today, before these new rules take effect. I am going to give you a clear step-by-step action plan that will keep you safe. Step number 1. Immediately create a complete inventory of every foreign financial connection you have. And I mean everything. Sit down with a piece of paper or open a document on your computer and make a detailed list. Write down every foreign bank account, no matter how small. Include accounts that are mostly empty or that you have not used in years. Write down any foreign retirement accounts or pension funds, even if you are not currently receiving payments from them. List any life insurance policies issued by foreign companies that have cash value. Include any ownership interests in foreign property, even if you only own a small percentage and even if the property does not generate rental income. Write down any foreign investment accounts, brokerage accounts, or business interests. For each item on your list, record the name of the financial institution, the country where it is located, the approximate account balance or value, and whether the account is in your name alone or jointly held with someone else. If you have old statements or documents, gather them and keep them together in one place. Many people get into terrible trouble simply because they never took the time to organize this basic information. Doing this one step now while you still have time can save you from enormous stress, massive penalties, and potential immigration problems later. Step number 2. Review your past FBAR filing history immediately. The FBAR, which stands for Foreign Bank Account Report, is not a new requirement. It has existed for many years. The rule is simple. If the total combined value of all your foreign financial accounts exceeds $10,000 at any point during the calendar year, you are required to file an FBAR electronically with FinCEN by April 15th of the following year. This requirement applies even if each individual account is small. For example, if you have 3 foreign accounts with $4,000 in each one, the total is $12,000, which means you must file an FBAR. Here's the problem. Millions of seniors and immigrants have never filed FBARs because they simply did not know the requirement existed. If you are realizing right now that you should have been filing FBARs for the past several years, but did not, do not panic, but also do not ignore it. The IRS and FinCEN offer what are called streamlined filing procedures that allow people to come into compliance with reduced penalties. If they can demonstrate that their failure to file was not willful or intentional, the absolute worst thing you can do is realize you have a problem and then do nothing, hoping it will somehow go away. It will not go away. And under the new 2026 system with automatic data sharing and lower thresholds, unreported accounts are going to be discovered. Taking action now to voluntarily correct past mistakes is infinitely better than waiting for the government to find the problem first. Step number 3. Begin preparing for the new 2026 reporting requirements right now. Because the thresholds are dropping to $5,000 or lower for seniors and immigrants, many people who have never had to file detailed foreign account reports before will suddenly be required to do so. If you believe your foreign financial assets might exceed the new lower limits, start collecting documentation immediately. This means gathering bank statements, account balance confirmations, and records that show the highest value of each account during the year. You will also need to convert foreign currency amounts into United States dollars using the appropriate exchange rates for the dates in question. This can be time-consuming and complicated, especially if you need to contact foreign banks or financial institutions to obtain old records or balance confirmations. Waiting until the last minute during tax season will make this process incredibly stressful and difficult. But if you start now while you still have plenty of time, you can gather everything you need in an organized, methodical way without pressure or panic. Step number 4. Make absolutely certain that you are correctly reporting all foreign income you receive. This is especially critical for seniors who receive pensions, annuities, or Social Security-type payments from other countries. Many people make the dangerous assumption that because their foreign income is already taxed in the country where it originates, they do not need to report it on their United States tax return. That assumption is almost always wrong. United States tax law requires you to report your worldwide income regardless of where it comes from and regardless of whether it was already taxed somewhere else. Some countries have tax treaties with the United States that can reduce or eliminate double taxation, but those treaties do not eliminate the reporting requirement. You still must disclose the income on your tax return in order to claim treaty benefits. Under the new 2026 rules, there will be specific mandatory questions on the standard tax return asking about foreign pensions, foreign Social Security benefits, and other foreign income sources. These questions will not be optional, and leaving them blank or answering them incorrectly will trigger automatic notices and potential investigations. If you are unsure about how to properly report foreign income, or if you are not sure whether a tax treaty applies to your situation, this is the time to speak with a qualified tax professional who has specific experience with international tax issues. Trying to figure this out on your own or guessing can lead to serious mistakes that will be very expensive to fix later. Step number 5. Keep organized, detailed records of absolutely everything related to your tax and financial reporting. This means saving copies of your completed tax returns, copies of any FBARs you file, copies of any other foreign account reports, and copies of all supporting documents like bank statements, balance confirmations, and currency conversion calculations. Store these records in a safe, organized place where you can easily find them if needed. This step is particularly important for green card holders and anyone who is planning to apply for United States citizenship in the future. During the naturalization process, USCIS may ask you to provide proof that you have complied with all tax filing and financial reporting requirements. If you have well-organized records that clearly show you filed everything correctly and reported everything honestly, the interview process can be simple and straightforward. But if you cannot easily produce documentation, or if your records are disorganized and incomplete, what should be a routine question can turn into a major problem that delays or even derails your citizenship application. Many immigration cases get delayed or denied not because the person actually did anything wrong, but simply because they could not prove they did things right. Good record keeping is one of the easiest and most effective ways to protect yourself. Now, to help you understand why all of this matters so much in real life, let me share a story that illustrates exactly what can happen when people are not prepared for these kinds of rule changes. This is a real situation that happened to someone I helped, and I am sharing it with you so you can see the consequences in concrete terms. Maria is a 72-year-old woman who immigrated to the United States from the Philippines nearly 30 years ago. She became a permanent resident, worked hard her entire life, and retired on a modest Social Security income. In the Philippines, she kept a small savings account with about $8,000 in it. She used this account maybe once a year when she traveled back home to visit family and to pay for medical care for her aging mother. From Maria's perspective, this account was completely separate from her American life. It was a small amount of money in a faraway country, and she never thought it had anything to do with her taxes or her immigration status. Maria always filed her tax returns honestly every year. She reported her Social Security income. She took her standard deduction. She never owed any taxes because her income was so low. She had no idea that she was supposed to file an F-bar or that she was supposed to report her foreign bank account. Nobody ever told her. The forms and instructions were buried in complicated IRS publications that she never saw. For nearly 15 years, she filed her taxes the same way every year, and nothing ever happened. Then in 2026, the new rules took effect. Maria filed her tax return the way she always did, but this time the return included new mandatory questions, specifically asking whether she had any foreign bank accounts. Maria did not really understand the question, and she was afraid that if she answered yes, it might create problems. So, she left it blank. A few months later, she received a letter from FinCEN, and the letter explained that under the new data sharing agreements, foreign banks are now required to report account information for United States persons to the United States government. Subscribe USA Move Guide for updates.